Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Indianapolis on September 28th through the 29th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and today's guest is Milos Barutciski. Milos is a partner with Bennett Jones in Toronto and co-chairs the firm's International Trade and Investment Practice Group, and he has represented Canadian and international clients in matters relating to foreign corrupt practices, export controls, trade sanctions, and other areas. Milos's experience is not just with the Foreign Corrupt Practices Act in the United States, but also Canada's FCPA-like law, the Corruption of Foreign Public Officials Act, the so-called CFPOA. Thanks for joining me today, Milos.
Thanks, Mike.
Canada's FCPA-like law, the CFPOA, is very similar to the U.S. Foreign Corrupt Practices Act, but it's not exactly a carbon copy. Can you share for listeners some of the key differences between the CFPOA and the FCPA?
Sure. Let's start with the two principal differences. There are others in point of detail we can get to later if need be, but I think the biggest difference is the Canadian law is purely criminal. There's no SEC administrative law equivalent with administrative or civil penalties. So Canadian enforcement, both from a legal interpretation and application standpoint and process standpoint, is hampered by the criminal burden of proof beyond a reasonable doubt and all the other trappings of criminal process. It's basically a blunt instrument that at sometimes and some instances is perhaps a little too blunt to deal with issues that are a little more subtle and that require a little more finesse. So that's probably the biggest difference. It's criminal only. There's nothing else. The second difference is that there's no equivalent, the second key difference at least, is that there's no Canadian equivalent to the SEC books and records provisions. So that is kind of an offshoot of the first issue. But we do have a books and records provision. There was a provision introduced in the 2013 amendments. However, it's criminal only, and then secondly, it focuses strictly on concealment of bribery. So from the standpoint of maintaining accurate books and records and anything of that sort, there's no general obligation under Canadian law, at least anti-corruption law, equivalent to what you have in the FCPA and SEC Act. So that, again, is a very significant difference given where enforcement has gone over the past many years in the U.S. There is an important aspect of our criminal books and records provision that hasn't had much attention, but I think is probably a sleeper in the long run, which is that the concealment issue for public companies is potentially more significant. And what I mean is, right now, there's nothing, it's probably for the first time this provision allows a senior corporate officer, a CFO or a CEO of a public company may create potential criminal liability, individual liability for those individuals for past conduct that they had nothing to do with, the past conduct of the company. So to illustrate the point, when the CFO is signing off on a company's financials and it comes to their attention that consultancy fee that we paid the engineers or the whoever third party overseas was in fact, we've just looked into it, it wasn't really a consultancy fee. Well, that CFO then is in a bit of a quandary. She or he is going to be hard-pressed to sign off on the financials knowing that the company's books and records contain an erroneous, in fact false, description of certain expenses. So that may very well start playing in the decision-making at senior levels regarding past conduct. So that's the sleeper, as I say, but it's come up now in a few instances dealing with clients.
And I think those are some important points for listeners to consider. It seems very popular nowadays for some people to compare U.S. enforcement of the Foreign Corrupt Practices Act with other nations' enforcement of their FCPA-like laws. But these are really apples to oranges comparisons for reasons you just said. There is no SEC equivalent in Canada under the CFPOA. And let's face it, a lot of FCPA enforcement actions are civil only and sometimes merely alleging or finding books and records and internal control violations. So really an apples to oranges comparison there that listeners need to keep in mind. So those are some changes in the actual statutes, and I guess we didn't mention the similarities, but generally speaking, both the FCPA and the CFPOA, prohibit the offering or payment of money or anything of value to a foreign official in connection with a business purpose. I'm vastly, overgeneralizing there, and there are some different statutory definitions. But what about how the law is enforced, both in terms of enforcement agency policy or resolution vehicles? What's different in Canada compared with how the DOJ or SEC may be going about their business?
Well, let's start with who is doing the enforcement. In Canada, until the 2013 amendments, every police department in the country and every prosecutor in the country, provincial, federal, territorial, or otherwise, theoretically had jurisdiction to investigate and ultimately prosecute CFPOA cases. That, by making everyone in charge, that essentially left no one in charge. So the record under the CFPOA, certainly for the first decade from 1999 when the Act came into force until until 2007, but practically speaking until a few years after that, when the dedicated RCMP anti-corruption unit was set up at late 2007, there was virtually no enforcement. There was one case that was brought to the RCMP's attention by actually a partner of mine back in the early 2000s and pretty much handed to them with a bow. But
and just for listeners' benefit, can you describe what the RCMP is?
Oh, sure. The RCMP is the Royal Canadian Mounted Police. This is our national, our federal police, usually referred to as the Mounties. No, they don't wear horses. They don't ride horses, and they don't wear the red serge except in ceremonial occasions. They generally are not uniformed, at least the investigators here. But what happened in 2007, which did change the enforcement environment, was that after a number of years of Canada being criticized for lack of enforcement and its less than ideal commitment to the OECD convention, the anti-corruption convention, the government of the day appointed a dedicated international anti-corruption unit staffed with 14 RCMP officers and a superintendent in charge, two branches, one out west in Calgary that focused on primarily the resource sector, but it was general, and then another one in the capital in Ottawa. That triggered, after a couple years of ramping up, some fairly increased enforcement, so that the RCMP, or Canada more generally, has now gone up in the rankings, not just of the OECD's evaluation, but also TI's evaluation as being a moderate enforcer as opposed to a poor enforcer. So that was a big difference at the time. But for the reasons I pointed out, since it's essentially criminal law enforcement, it is hampered by the trappings of criminal investigation. There is no subpoena power under our laws. There is equivalent a criminal investigative order, production order, that can only go to a non-target. So those are frequently used. The RCMP will get the court order to go to be issued to financial institutions and maybe in the follow the money context. But you can't use those vis-a-vis a target of investigation the way the SEC might issue a subpoena. The other aspect of it is, so the investigative tools that the RCMP have are essentially traditional on-the-ground, boots-on-the-ground questioning, looking for questioning witnesses on a voluntary basis, first, and then secondly, search warrants, which again are a pretty heavy-handed vehicle, and having been involved in numerous search warrants over the years, a very expensive tool for the RCMP. So when you execute a search warrant, it's not just the legal processes that you actually have to, first of all, build a fairly significant case for the court, but then the logistic trappings of establishing a team, which is usually a sizable team, and with the forensic backup and so forth to execute the search warrant, there's a significant amount of cost, so they don't do it lightly. Having said that, they have done it. I'm aware of at least 5 search warrants that have been executed over the past 8 or 9 years in CFPOA cases. So that's one aspect to keep in mind. That said, while the RCMP obtained dedicated staff in late 2007, took them a few years to ramp up, and then they started laying charges in 2010, I think, was the first set of charges. That unit, and then after a while, they started getting up to speed. So they have had some enforcement successes. There was the NICO prosecution, which led to ultimately a guilty plea and a fine in the tune of $9.5 million, give or take. Subsequently, there was another one based on a voluntary disclosure in the Griffiths Energy case that led to about a $10.5 million fine, which the court characterized as being a credit, given it would have been much higher but for the fact that the company made a voluntary disclosure. Another individual in the Carragher case was sentenced to 3 years imprisonment. That sentence was appealed, and the Ontario Court of Appeal dismissed the appeal actually just last Thursday, so essentially upheld the sentence and the conviction, and Mr. Carragher, unless he is able to obtain leave from the Supreme Court, will be serving his time. So there have been some and there have been other charges and a number of other charges pending. There have also been a few losses, none at trial on the merits, though on some procedural issues. There have been investigations dismissed and charges in the case of the individuals charged in a Bangladesh-based investigation that involved their employer, SNC Lavalin. The charges against them were ultimately dismissed because the principal evidence, which was wiretap evidence, was ultimately dismissed by the Superior Court. So there have been, by and large, some pretty decent successes. The other tool that they use is immunity for individuals. In the Carragher case, and one other instance that I'm aware of, but in the Carragher, it's public. The evidence against Carragher was both search warrant information, but also testimony from an individual of the company. I think he was CFO or in any event executive of the company that was involved in the matter, was given immunity in exchange for his testimony. So that is a tool that's routinely used in white-collar cases in Canada, be they fraud cases or cartel cases, price-fixing cases, anything of the sort. In fact, most criminal charges, immunity is often used for witnesses. So that's available. The one thing that we don't, and then finally, declinations. The RCMP can, and has issued or declined to prosecute cases. In at least one instance, they did it formally through a letter closing the investigation. That was in the public record, the Nordion case that after a voluntary disclosure to the RCMP, the SEC, and the DOJ, the RCMP ultimately, I think it was basically almost 3 years later, issued a declination and chose, on the basis of the evidence to date, that charges weren't warranted. The DOJ took no action, and the SEC ultimately obtained a consent order and a $325,000 fine on a books and records violation on the U.S. side. So that is something, and they have done it in other instances, at least one other, in an informal manner where they didn't issue a letter that I'm aware of, and I'm sure they've done similar things elsewhere. So those are pretty traditional approaches. What we don't have, which is a notable difference between Canada, the United States, and other jurisdictions, is DPAs, deferred prosecution agreements. And that is more a matter of policy choice than law. In fact, there's a vigorous debate whether or not DPAs are legally permissible. I think my view is that they're unquestionably permissible under our law. The problem was the previous government, the conservative government that was that lost power in 2015, did not like DPAs, and ultimately the RCMP felt that they couldn't go forward with DPAs unless they had some kind of political backing for that kind of a process. So they haven't been used to date in Canada, though the idea of a DPA is not much different from settlement of a case on the basis of a corporate immunity agreement, which we use routinely in cartel cases and price-fixing cases. In fact, the Competition Bureau has a formal immunity and preferential treatment policy where the first in to disclose a cartel gets a recommendation from immunity, and pursuant to an MOU between the Attorney General and the Competition Bureau, they will almost invariably obtain immunity from the Attorney General or the Director of Public Prosecution.
Well, and another thing that Canada doesn't have is non-prosecution agreements too, which are frequently used in connection with FCPA enforcement actions. And this goes, to the point made earlier about this apples to oranges comparison. It's very difficult and really not very meaningful at all to compare enforcement of the CFPOA, which is criminal only and which makes use of what I'll call traditional law enforcement tools. It's very difficult and not very meaningful to compare that to enforcement of the Foreign Corrupt Practices Act, which, as we've already mentioned, is civil as well as criminal. And then even on the criminal side, the DOJ uses a virtual buffet line of resolution vehicles, pleas, MPAs, DPAs, and with increasing frequency, so-called declinations with disgorgement.
Right, and you're quite right. We don't have non-prosecution agreements, and that's really a function of the same uncertainty at the enforcement side, namely the RCMP and the Public Prosecution Service, as to can they actually use those instruments, and will they have political cover, or will they take flack from the political side? As I say, that's a policy choice, and they've decided not to pursue that route. Having said that, there is an active study, and I expect there may very well be developments shortly within the next few weeks, quite possibly, of the merits of using DPAs. That's been under study within government now for some time, and at least what I'm hearing now is that a broader and more formal process to examine and perhaps obtain consultation and feedback, ultimately leading to the introduction of a statutory DPA model may be in the offing. Either way, I think there is an appetite among enforcement officials and the government to get over that issue, but at this stage I think it's primarily political, though the fix may or may not be statutory. They need to get over that political hump first before they actually do anything.
Now, you mentioned the Nordion enforcement action a few minutes ago. Nordion is, or was, approximately one of 300 Canadian companies that have shares listed on a U.S. exchange. And anytime a foreign company has shares listed on a U.S. exchange, they're subject to the FCPA, both the anti-bribery provisions as well as books and records and internal control provisions. And then even furthermore, assuming a certain jurisdictional nexus is met, Canadian companies or any Canadian nationals could become subject to the FCPA. In your opinion, are relevant Canadian companies more concerned with becoming the subject of an FCPA inquiry or a CFPOA inquiry?
Well, it's hard to say whether they're more concerned about one or the other. From an objective standpoint, I'll talk in a minute to my sort of anecdotal experience dealing with clients who I'm acting for who are exposed on both sides. But from an objective standpoint, most companies are certainly aware that that the enforcement record in the United States, as well as the penalties, are more, at least on first blush, more severe and more draconian. There is more enforcement. The sheer volume of cases that are brought in the United States is very, very different from Canada. So that would suggest that people would be more attuned to the U.S. side. Similarly, the penalties. On the penalty side, again, the two bigger cases, Nyko and Griffiths, were fairly substantial penalties, and going to jail for 3 years compares fairly well with the very few individual penalties you've had in the United States. When I say compares very well from a severity standpoint, and there have been other individuals charged. There are 3 other individuals pending trial now in CFPOA cases. So the record suggests that Canadian officers, directors, and employees have perfectly good reason to fear Canadian enforcement when it does occur. The issue that might make people think twice as well about one or the other is that the U.S. has actually not gone after too many Canadian companies to date, though given the number of Canadian issuers, you would have thought there would be plenty of opportunity to have done so. What happened was in the mid-2000s rather, the U.S. government started going after, whether by design or just happenstance, started going after foreign companies. And today, I think the record shows that they will just as often, if not even more often, go after foreign companies, issuers as American companies. Canadian companies don't figure in that world as targets U.S. Now, so I scratched my head and asked myself why. Part of it, I think, based on cases where I've been involved, where both sides' authorities are involved in one sense or another, is there is a sense, I believe, on the U.S. side that Canada's enforcement is ramping up and they don't need to slap Canada and the Canadian government hard by going after the companies as intensely as they might in certain other jurisdictions. I don't want to overstate that. So I have no doubt that the SEC and DOJ will go after Canadian companies when the evidence warrants it. But the fact that the Canadian government or the RCMP in particular have taken a more active role in CFPOA cases does, I believe, make a difference. Now, stepping to the more anecdotal, talking to clients, yes, they are far more aware of the severity of sentences and the frequency of prosecution and enforcement in the United States. However, if you're a Canadian officer, director, or executive of a company, private or public, even if you know the U.S. Authorities have jurisdiction, you are still sitting in Canada, and you have those folks at the RCMP to deal with. And so you take that seriously, too. So I've yet to see a client, when they're faced with conduct that is primarily Canadian-based, in the sense that it's a Canadian company with little or limited activity in the United States, though subject to U.S. jurisdiction because they're issuers. I've yet to see a company that says, well, we don't really care what about the Canadian side, what's going to happen to us with the SEC and DOJ front. They kind of are concerned with both, because if there is parallel enforcement, especially if they go after individuals, their principal source of liability on the individual basis is going to be in Canada. So people take both fairly seriously. I think it's not a issue of being more afraid of one than the other. When you are in the potential target zone, you're concerned about the whole exposure, and you want to make sure that you're covering in your actions and your decisions to disclose or not to disclose, to remediate and so forth, that your actions will cover off exposure down the line on both sides of the border if and when the matter comes to the attention of the authorities.
Well, the final question is, from your perspective as a Canadian lawyer with substantial, real-world practical experience with the FCPA as well, how could the statute itself, or perhaps FCPA enforcement policy at the DOJ or SEC, be improved? What is your two-step program, perhaps, to make the FCPA more effective?
Well, I'll put this in the context of the FCPA and U.S. enforcement by those agencies, but I think it applies to other agencies that have been involved in several World Bank investigations and other investigations that involved other jurisdictions. And at the end of the day, all of the enforcement agencies talk a good line about the value of voluntary cooperation, the value of internal investigations, and voluntary remediation of problems. But walking the walk is a little bit more challenging. And my own view, starting with the very first World Bank case way back in 1999, when like a year after the debarment policy was issued, that case took another 4 years for us to wrap up after two hearings before the Sanctions Committee. The flavor I had there, and I've had since, both on the Canadian, U.S., and other international side, is that it's almost as if no good deed goes unpunished. If you put yourself, while the agencies make a big deal and talk, as I say, a good line, I think it's well-intentioned, to say that companies that voluntarily disclose, or even if they don't voluntarily disclose, if they take appropriate actions to terminate conduct, to discipline rogue employees, to essentially implement compliance. Everybody says compliance is not a guarantee. Having compliance mechanisms and effective compliance is not a guarantee that nothing will ever happen. People understand that, but practically speaking, the agencies still have a tendency to put your feet to the fire. So the companies that invest in compliance and that come forward are often put to the thumbscrew, sort of the medieval torture treatment. And I'm not sure that makes sense. If you want companies to comply and come forth and disclose so that you as an enforcer can then go after others and individuals and so forth, then you need to actually make it worth their while. And I've yet to see an instance where, I'm not saying it hasn't happened, but I've yet to see an instance where a company, to get the benefit of having done the right thing, hasn't, in addition to doing the right thing, had to spend tens or hundreds of millions of dollars to prove that they've done the right thing to the agencies. So if there was a place where I think the OJ and SEC could improve their approach, is to breathe a bit more life and substance into the commitment that they've made in their guidelines, for example, and elsewhere, to voluntary disclosure and voluntary action and voluntary remediation.
Well, that's what the goal of the pilot program was, released in April of 2016, and what the future of that pilot program will look like obviously remains to be seen. So thank you for joining us today, Milos. Again, our guest has been Milos Barutciski, partner at Bennett Jones in Toronto. And anyone out there who is interested or has issues concerning the intersection of the Foreign Corrupt Practices Act or Canada's Corruption of Foreign Public Officials Act, you might want to look Milos and his team up, as they can no doubt help you. So thank you.